Attorney Barry Ward, can you explain the elements of a malpractice case, please?
Sure, Bill. A malpractice case involves injury caused by the failure of a professional, a doctor, a lawyer, an accountant, a dentist, any type of professional, to properly perform their job on behalf of a client or patient. There are three basic elements: failure to meet the reasonable standard of care expected of a professional for the particular job. For example, failure to timely diagnose a medical condition or to properly treat a medical condition. The second basic element is what the law calls proximate cause, and the third element is harm, proof of harm and injury. I'll address each standard individually. Main thing to remember about a professional malpractice case is that the law will require, in the great majority of cases, testimony from an expert witness, a professional in the field of the professional whose malpractice is at question, to give opinion testimony. And I'll comment on opinion testimonies since it is so critical to a malpractice case. The rules of legal evidence are that usually opinions are not admissible evidence in court. The exception to that is in a professional malpractice case where the issues involve special knowledge of a field that most jurors, lay people, most people wouldn't know of their own knowledge. An expert in that field is required to explain it, and they are allowed to give opinions. So, for example, in a medical malpractice case involving, let us say, failure to timely diagnose a disease, an expert would be needed to testify first as to what the standard of care is regarding, in a particular situation, for example, a pediatrician or pediatric nurse seeing an infant in a well child visit who exhibited certain symptoms. And you would need an expert to say that on those facts, or that at such a visit, this is the standard of care for what should be done, and give an opinion as to whether or not that was done or properly done, and give an opinion as to if certain symptoms were shown, then you would need an opinion from the expert witness to say, well, a professional having knowledge of those symptoms should, as a minimum, run these tests, and those tests weren't run. And that's an example of that. The next legal question, after failure to perform in accordance with the reasonable standard of care for a professional in that circumstance, is proximate cause of the harm claimed. Proximate cause is obviously a legal term. Its most basic definition is whether or not a particular act or failure to act, a failure to timely refer somebody for a particular test or timely diagnose a particular disease, for example, was a substantial factor in causing harm. Let us use, for example, a death case. If the allegation is that due to a doctor's malpractice, someone has died because their disease was not timely treated, proof from an expert witness is necessary to show that timely intervention would have more likely than not resulted in the patient surviving. And that is always going to be a toughly contested issue in a medical malpractice case, the defense will always, in my experience, be able to find their own experts. Certainly on that question of proximate cause. I think it's harder, or let me say, it can be clearer that someone's failed to meet the standard of care, because the standard of care is a known quantity, and there should be some consensus about what the reasonable standard of care is in a particular field as far as what you should do in a particular situation. But the proximate cause question is almost always going to be purely a matter of opinion, because if someone has a life-threatening disease, then absent treatment, they're more likely than not going to survive. And judging those matters of probability can become a difficult question. Ultimately, in many cases, it's based upon statistical data. And in many cases, in a particular situation, the field of medicine doesn't necessarily have a widely broad base of statistical data to reach that conclusion regarding whether it's more probable than not that someone would survive, for example. And the law in some states, but not in Connecticut. In some states, compensation is allowed even where there's less than a 50% chance or likelihood that someone would have had a more favorable outcome. But in Connecticut, the testimony has to be that it was more likely than not that proper care would have resulted in a more appropriate outcome. And the third part is that the opinion regarding proximate cause has to link the malpractice, the negligence, to a specific harm. That ultimately, and then the fourth criterion, which is an element in any personal injury case, is what is fair compensation for the harm done. So once you have the opinion linking the negligence of the professional to the harm, then the last question is, what compensation does the law provide for that harm? Generally in personal injury cases, which I have discussed personal injury cases elsewhere, the law calls for, quote, fair and just compensation, close quote, for physical pain and suffering, economic consequences, lost income, loss of the ability to earn income, medical expenses incurred as a result of the negligence. If in a case where the negligence has caused physical harm, the impact that the physical harm has on the injured person's usual lifestyle, on their ability to get about actively as a well person. If, for example, a professional sports star was physically injured by professional malpractice of a medical care provider so that they could no longer play their sport, obviously there would be substantial economic damages from losing their livelihood, and depending upon the extent that their physical actions were limited, they'd be entitled to compensation generally for the limitation on their activities as well.